Well, greetings again. Now, on Lesson 25, we're continuing with the balance of the state's case. In Lessons 24 and 25, 23 and 24, we covered the jury and we covered the state's case. Now, we're working off of a preliminary hearing that actually occurred, a case that you've had since Lesson 9. And as we're going through the transcript of the preliminary hearing, what we're showing you here is that had this case gone to trial, this would have been the general scenario of the state's case, the state's witnesses. And the state and the defendant would have gone over the preliminary hearing transcript to see whether or not Officer DeLeonard and Officer Honey could stick to their story. So let's pick up the scenario with Officer DeLeonard, who is still on the witness stand, and let's watch and monitor what he's saying and what he's testifying to, so that we can, when we put on the defendant's half of the case, we can see what lies, inconsistencies, half-truths, and evasions of the truth that we can pick up to impeach the state's case. Let's pick it up in the courtroom again.
Court is back in session now. Mr. DeLeonard, you remember you're still under oath.
Yes, Your Honor.
Mr. Gordon, you may continue your questioning.
Thank you, Your Honor.
Mr. DeLeonard, did I make the statement that I demand all my rights of common law?
That's right.
And I waive none of them at any time?
That's right, sir. That's what you said.
Okay. So then you know that I was demanding all of my rights?
Right, sir.
Well, then did it occur to you that there was a rights issue involved, that I was claiming a right?
Objection, Your Honor. I'm going to have to continue these objections to these irrelevant and immaterial matters that Mr. Gordon continually brings up.
He knows whether or not.
I'm going to object to this. It's already been asked and answered and asked and answered over and over.
Yes, I think he answered that. Yes.
Yes, he knew?
Yes.
So essentially then the defendant, when you're testifying, was raising constitutional objections to the book.
Objection. Asked and answered twice before.
Yes, that's the same question again, Mr. Gordon. Objection sustained.
He's answered the question. Yeah, that's right. He understands and knows that.
Yes, that's what he said.
Is this the only thing that he is testifying to, or is this one charge and nothing concerning the other charge, the felony?
Yes.
That's all Mr. Carnahan has asked him about.
I don't have any counts here to keep notes for me, so I'm trying to remember as I go along.
It appears that some of the people in the audience are taking notes for you.
But I don't have anybody right here. Did I make the statement to you, or do you remember me making the statement to you? These fingerprints are the beginning point of a criminal investigation and therefore in violation of my constitutional rights under Miranda?
No, sir, I don't recall those words.
You don't recall it?
I don't recall them, sir.
Let me ask you this. Could I have said that and you just don't remember?
Sure, you could have said a lot of things I couldn't remember. I'm sure of that.
Was the behavior of this defendant somewhat unusual in your experience?
Yeah, very much. Yes, sir.
Very much so?
Yes.
I don't believe I had any more questions if that's all that he is going to testify to is this one event. I believe that's covered under the rights issue, and I'll sum up on that.
The state has no further questions of this witness, and the state rests at this time, Your Honor.
Thank you, Mr. DeLeonard. You may be excused.
Thank you, Your Honor.
Mr. Gordon, are you ready to proceed?
Your Honor, I have a motion that I'd like to bring before the court at this time.
Hold it. Bailiff, would you take the jury out?
The jury would follow me.
Okay, Mr. Gordon, go ahead.
I'd like to challenge the state's prima facie case at this time, being that the state has produced no physical evidence. I've requested that this alleged gel suit that's supposedly torn up, asked to have it brought forward as evidence before, and then today it was not brought here. Also, they have testified that there was only 11 pieces to the gel suit, and it's a known fact that it takes 15 pieces to make up that suit, Your Honor, and therefore I'd like to suggest to the court that it's pretty evident that I think I was framed on this, and that they simply just took a suit that had been torn up for cleaning purposes or something and tossed that under my bunk just to try and frame me. There was no photographs of anything produced here, nothing to indicate anything towards the charge of breaking down jails, in which that is the charge, not tearing up jail clothes or anything else. That statute on breaking down jails applies to actually destroying the jail itself. And furthermore, Your Honor, there's been no proof that they even had a jail around to tear up. And there's no bricks or anything. If I wrote on the walls, would that be breaking down the jail? Another thing, too, Your Honor, was as far as jurisdiction, there was no proof by the state that this alleged event even occurred in Ada County, nor was there any eyewitnesses produced that could testify that they actually saw me tear up the jail clothes or anything else. And also, Your Honor, I believe that the state has failed to prove that the defendant was guilty beyond a reasonable doubt. Totally, the state has failed to prove their case, and therefore I would move for dismissal on those grounds, Your Honor.
Well,
I'm prepared to respond to that on behalf of the state, Your Honor.
Go ahead, Mr. Carnahan.
Thank you, Your Honor. I submit to the court that we have, in fact, proven the case beyond a reasonable doubt, and that the prima facie case has, in fact, been demonstrated. We don't have to prove, we don't have to show physical evidence. We've had testimony here today from 2 eyewitnesses that the evidence was torn up. There's nothing in the rules of procedure, nor in the statutes of Idaho that require that the state produce physical evidence. And to say that the state has failed to produce on the face of it a case is specious and frivolous and without any foundation or merit whatsoever. You've heard Officer DeLeonard and Officer Honey both testify that Mr. Gordon was in the jail cell, that the jail suit was torn up, that those facts were established by testimony, and irrefutable testimony, and qualified testimony, and unimpeachable testimony, because they're police officers. And in addition to that, the charge of breaking down jails does cover the things that are in the jail, such as jail clothes and shoes and the windows and the bricks and the walls and the bars. Anytime a prisoner breaks or destroys anything in the jail, he's guilty of breaking down jails. And to assert that the state doesn't have jurisdiction or has failed to assert and prove jurisdiction is another one of Mr. Gordon's specious and frivolous tricks to convince the court that there's some technical reason why he should be released or that this case should be dismissed. And it's well known that Mr. Gordon does this for the fun of it, and that he's just attempting to cost the taxpayers money, and that we've shown a prima facie case, and that this court has jurisdiction is on the very face of it, evident here by the testimony of the police officers. What do you mean, no eyewitnesses, Mr. Gordon? Why, Mr. Honey and Mr. DeLeonard both testified that they know that you tore that jail suit up. And even on the face of your own testimony and then by your own questioning, we know that you refused to be fingerprinted and booked, and that you were uncooperative, and that you resisted arrest. And we didn't even charge Mr. Gordon with all of the charges that we could have charged him with. We could have charged him with resisting arrests, both in the jail and at the booking procedure. And you heard of the disgusting and the disgraceful display that Mr. Gordon presented himself before the court in his underwear when he refused to be dressed after he had torn up his jail clothes. And to say that we had no eyewitnesses, another specious and frivolous trick that Mr. Gordon is attempting to use here to take the court's attention away from his despicable acts. And he is, in fact, guilty beyond a reasonable doubt. We've shown conclusively that Mr. Gordon, by testimony of the officers, has done these acts and that there was no one else who could, and that he has a history of doing things like this, and it's for that reason, Your Honor, that Mr. Gordon's motion should be denied.
I think Mr. Gordon has raised some very interesting points in his motion. Under some circumstances, I think that his motion could well be granted, but I find this to be quite a fascinating case, and I would like to hear the defendant's half of the case.
In the defendant's half of the case, it's the most important part of the case to you. You know, I kid my students, in the first half of the case, you can sit here and count flies on the ceiling or do whatever you want. Now, in reality, in that first half of the case, you should have been sitting there copiously taking notes and going over the testimony of the prosecutor concerning the state's witnesses, looking for every lie, every untruth, or every mistake made, so that on direct examination in your half of the case, when you bring Officer Honey and Officer DeLeonard back, you concentrate on impeaching their testimony. Now, the prosecutor in the first half of the case appeared to be a bumbling dolt. Actually, the fellow that plays it is not a bumbling dolt at all. But we did that to illustrate a fact or a point. What you have is typically in traffic cases and magistrate courts is a lot of times the judge himself will be a lay person, a political hack and an appointee. If he is a judge who has been to law school, he's probably a judge because he couldn't make it in the legal profession. So he's paid $20,000 or $25,000 a year to be a magistrate judge in a traffic court because he can't make it out there with the F. Lee Baileys and the other successful attorneys in town. And our experience has shown us that they're typically, when it comes to constitutional law, of the most ignorant sort of people. And in addition, they're even worse than that. They're arrogant. They act like they know everything, and they really don't know very much. In fact, knowing very much would be a blessing in disguise. If they knew a little something of the Constitution, I think we'd have less complaint. Many of them know absolutely nothing, or near to it. The prosecutors typically are right out of law school, and that's why they're working in the prosecutor's offices because, or in the public defender's offices, because they can't get a job anywhere else. And all of those fellows, after they get a little experience, or the ladies, when they get a little experience, they'll go out into private practice. That's why when you walk into court with a public defender, you've got just a bit better than nothing. And if you're a competent pro se, it's a hell of a lot less than nothing. Now, the prosecutor, if you're a good competent pro se, is actually your junior, because he's probably not as experienced or as knowledgeable as you are. Your first 2 or 3 cases, though, he's going to be 10 times better than you are because he's been to law school and you haven't. That's why you need to do your first 3 or 4 cases in the traffic court, so that if you get laid away, so what? Pay him a $100 fine and go on. All right, so now we're going to bring in a new cast of characters. I'm going to play myself in the second half of the case for the purpose of showing you that I was there. I know what Honey said. I know what DeLeonard said. I know what I said. I know what the other characters said. Now, do you see, when you have a public defender, or even if you hire a lawyer, he's always got the information secondhand. He never knows, of his own knowledge that Honey said this or said that at this time with this particular inflection in his voice. And that's why you're a better candidate to defend yourself, simply because you know everything that went on, how it came down, and why. And if you're a good, competent pro se, you're the one that wrote the script at the scene of the crime and directed the way the policeman would answer or ask questions. So let's pick up then on the defendant's half of the case with me playing the defendant, and we'll have Mr. Carnahan over here played by another good, competent pro se, and we'll change our characters a little bit now. And I'm going to bring back in the people who are in the jail cell, that is the other prisoners, and Officer Honey and Officer DeLeonard, for the express purpose of running through all these questions again, so that I can show you how on cross-examination and on direct examination we're going to impeach their testimony. We're out to show that they're liars. So let's pick it up right there.
Hear ye, all rise, please. The 4th District Court of Ada County is now in session. Judge John Curtis presiding.
Thank you. You may be seated. Mr. Gordon, this is the defendant's half of the case. Mr. Gordon, are you ready to proceed?
Yes, Your Honor, we're ready to proceed.
Mr. Carnahan, are you ready for the state?
Yes, we're ready.
Mr. Gordon, you may call your first witness.
Okay, as my first witness, I think I'll call Mr. Pat Conley.
Please raise your right hand and repeat after me. I do hereby solemnly swear to tell the public no death truth so help me God.
I do.
Thank you. You may be seated.
Mr. Conley, would you state your name for the record and spell it, please?
My name is Pat Conley, Conley.
And Mr. Conley, how are you employed?
Oh, I'm a freelance illustrator.
And Mr. Conley, I want to take your attention back to approximately April 8th or 9th, 1982. Did you have occasion to be in the Ada County Jail on the morning of April 9th, 1982?
Yes, I did.
And would you relate to us, please, or just briefly, what the circumstances were that brought you to the Ada County Jail?
Well, I had been out partying a little bit that night with some friends, and apparently I had too much to drink, and a police officer found me and arrested me.
So you're charged with DWI?
I believe that's what they...
Objection, Your Honor. That's irrelevant. It has no bearing on this case.
Objection sustained.
You were in the same jail cell as the defendant, George Gordon?
I was.
And can you begin by doing this? What time did you get into the jail that night?
Oh, I think it was about 1 in the morning, 1:30, somewhere in there.
Okay, and how many other prisoners were in the...
Objection. That has no bearing on the case.
I think perhaps it may have. Objection overruled.
Thank you, Your Honor. How many other people were in that particular jail cell with the defendant Gordon when you got there?
I think it was about 7 of them.
Did that include Gordon?
Yes, it did.
And you went to bed at about 1 o'clock or 1:30 or so?
Yeah, whenever.
And what time did you get up?
Well, I got up when the lights come on. It must have been about 5 or 5:30 in the morning.
Was it still dark outside?
Objection, Your Honor. What does the darkness or what time he got up have to do with it?
Mr. Gordon, I think it may have bearing. I'll overrule your objection.
Thank you, Your Honor.
I think we're just barely starting to get light out. The sun doesn't rise till about 6:30 in the morning, but it's still getting lighter.
Okay, and this was in the spring. It was in April. So I'm trying to establish the time that these events took place.
The time that the guards come in, when they bring the breakfast in, when they pick up the trays, they bring the razors in, they come in and call off names they take out for arraignment, different things during the day. Television is in there. If they got it turned on, they could ascertain the time by it.
Mm-hmm. Okay, and so did you eat breakfast that morning?
No, I got up, but I didn't feel like eating breakfast that morning.
Okay, and did the defendant Gordon eat breakfast that morning?
Yes, he did. I recall.
And is there a big metal table in that room?
Yes, there is.
And was Gordon sitting at the big metal table? This was in the spring. It was in April. So I'm trying to establish the time that these events took place. Was there a clock in that cell?
No, there wasn't.
So since there was no clock in that cell, how did you tell time? How did the prisoners tell time in the jail cell?
Mostly by the time that the guards come in, when they bring the breakfast in, when they pick up the trays, they bring the razors in, they come in and call off names they take out for arraignment, different things during the day. Television is in there. If they got it turned on, they could ascertain the time by it.
Mm-hmm. Okay, and so did you eat breakfast that morning?
No, I got up, but I didn't feel like eating breakfast that morning.
Okay, and did the defendant Gordon eat breakfast that morning?
Yes, he did. I recall.
And Is there a big metal table in that room?
Yes, there is.
And was Gordon sitting at the big metal table during breakfast?
Yes.
And
Your Honor, these are leading questions. Do they need to be asked?
Are you objecting?
I'm objecting to them as being leading questions. He's putting questions in the witness's mouth.
Your objections are sustained. You will not lead the witness, Mr. Gordon.
okay, I'm sorry, Your Honor. I'll rephrase the question. Would you describe the table that's in the room, that jail cell room?
Well, it's a rectangular table with legs underneath it that keeps it up off the floor.
And how many seats are there at that table?
Well, there must be about 8 of them, I would say.
And
I never counted them. I'm just guessing at that.
where is that table located in reference to the bunks that are in the room?
Well, let's see. The bunk sit over here on this end, and the door is over here, and the table sits over here,
And
opposite the bunks. And
did you observe Officer Honey come into the jail cell at any time that morning?
yes, I did. He come in several times that morning.
And would you describe for us in your own words, please, the events that you observed?
Each time he come into the room,
Yes.
Well, he come in to the room to pick up the trays after breakfast, and I think he come back in, brought razors in for everyone. He come back in again with a list in his hand. He was calling names off for arraignment. I think it must have been about 3 times I recall that he come in. It could have been more, but
Now, during the night, did any guards come into that cell after you got in there?
That's irrelevant where they came in that night.
I'm going to object to this, Your Honor. The prosecutor continually interrupts before I've even got the question out. And he's not objecting properly, and I think it's time that someone said something to him about it.
Yes, Mr. Carnahan, if you want to object, please state your objection and let Mr. Gordon speak. If you want, don't interrupt Mr. Gordon unless you have a specific objection to make, and make it in the form of an objection, please.
Thank you, Your Honor.
Yes, Your Honor.
Let me ask this question again. You came in at 1 o'clock in the morning, and did the jail guards come into the jail cell at any time during the night?
yes, they did. Not being in my own bed, I didn't sleep very well that night, and I was constantly interrupted every so often by somebody walking in and out of the jail cell.
So you heard jail guards come in and out from time to time, is that correct?
Yes.
How often, or let's ask the question this way, how many times can you estimate? Or
Oh, I don't know. It seemed like they must have been every 15, 20 minutes, 30 minutes, something like that. I'd just start to fall asleep, and then they'd wake me up again.
So between 1 o'clock when you got in until about 6 o'clock in the morning, let's see, that's 5 hours. Would you say that they came in sometime maybe around 10 times total?
Oh, easily, yeah, I would say it. I was constantly awakened by them.
All right. Now, bringing your attention up to around the last time that Officer Honey came in, you say he was reading off some names?
Yeah, he had a list of names. He's calling off these names and for people to go out, apparently for arraignment or something, so I understand it.
And was the defendant one of those names on the list?
He didn't get to that calling the defendant's name because he walked right up to the defendant, George Gordon, and we had been standing there talking, and George was in his underwear, and he looked George right in the eye, and he says, "Get dressed, George," or George Gordon, and then while he stared at me, I said, "George, did you tear up your prison suit?" And George just stood there and looked at him. You want me to continue with what happened?
Then what happened?
Well, then he turned around and walked over to the bunk and reached under the bunk and pulled the prison suit out from under the bunk and started to swear at George. He come up and he grabbed him by the his undershirt, and he called him some names and told me he just committed a felony, and he got really belligerent, just like a wild man.
Now, this is important. Let me ask you this question this way. Did he say to Gordon, Gordon, did you tear up your jail suit before he went over and picked up the pile of rags, or after he went over and picked up the
Before. It was right after. The first thing he asked George was, he told George to get dressed, and he said, did you tear up your jail suit? So it was before.
Now, in your mind, did that tell you that he knew that that jail suit was tore up before he went over to the bunk and picked up the rags?
Well, I didn't really think about it at the time.
But what do you think now?
Objection.
Well, objection sustained.
Well, I think that's a proper question, Your Honor. It's his mind, and he's here, and he's testifying. He can tell us.
It's a leading question, Your Honor, and he's putting answers in the witness's mouth.
Objection sustained. You may proceed, Mr. Gordon.
Well, let's rephrase the question then. Did it appear to you at the time that Officer Honey knew that the jail suit was torn up before he went over and picked it up?
It sure seemed that way.
Was there ample opportunity during the night for someone to come in and exchange a pile of rags for the...
Well, with all the people or whoever was coming in and out of there, almost anything could have happened.
It could have occurred then.
Yes, it could have.
All right. Now, did you ever observe the defendant Gordon wearing that jail suit at any time?
No, I didn't.
How was the defendant dressed?
Well, he was in his underwear.
Did that look strange and peculiar?
Yes, I would say it did.
Everyone else in there had their jail clothes on?
Yeah, I don't recall anybody else in their underwear at that time of the morning anyway. If they had been in their underwear, they may have gotten dressed.
But you did notice that the defendant Gordon did not have a jail suit on.
That's right. I was standing there right by the table talking to him, and I had the duty of mopping up that morning, and I had my mop and bucket with me, and we were talking when Officer Honey come in.
And did Officer Honey then, after he was swearing and yelling at defendant Gordon, did he use the words, "You stupid SOB, this is a felony"?
I believe those were his exact words.
Okay. So he knew that it was a felony then, right then in the jail cell, is that correct?
Well, he's a cop. He should know.
But he used the words felony. He didn't say you're under arrest and we'll charge you later?
No. He said you committed a felony.
Okay. I don't believe I have any more questions of this witness, Your Honor.
Mr. Carnahan, you may cross.